Hello, Michigan Realtors, and welcome back to From the Mailbag. I'm Becky Gean, and today's Q&A builds on our most recent Letter of the Law video, where Brian Westron addressed some of the methods that buyer's agents are using to make their buyer clients' offers more attractive to sellers. In this video, we'll discuss some of the questions we received on that topic. With that, let's dive into some questions from the mailbag. Question 1. I'm representing the sellers in the sale of their home. There have been some delays and the buyer has asked for yet another extension. My sellers will only give the buyer an extension if the buyer agrees to a $2,000 non-refundable deposit, but I've heard that non-refundable deposits are illegal. Is this true? No, this is not true. A buyer and seller can certainly agree that a deposit will be non-refundable, but you want to make sure that this is explicitly stated in the contract so that there can be no argument about the party's intent or about what happens to that deposit if the transaction fails. Question 2. I represent a buyer who submitted an offer on a home where there were multiple offers. My client's offer was not accepted. We have reason to believe that my client's offer was the highest and best. Are we entitled to see a copy of the accepted offer so that we can verify that it was in fact the highest and best offer? The answer here is no. It doesn't matter whether or not the accepted offer was the highest and best, because the sellers are not required to accept the highest and best offer or even treat all offers equally. Sellers can accept or reject an offer for any reason as long as they don't engage in unlawful discrimination. For example, discrimination based on national origin or religion or any other protected classification under state, federal, or local fair housing law. Question 3. My seller entered into a purchase agreement that contains a clause that says that the earnest money deposit will become non-refundable if the closing does not occur by the date specified in the agreement. The closing date has passed, but the buyer is disputing the release of the money. Since the contract is clear that the deposit is non-refundable, can the money be released to the seller? The answer here is no. If there's a dispute between the buyer and the seller over the earnest money deposit, the law requires that the money stay in a broker's trust account until there's either an agreement between the parties or a court order. This is true even in a case like this, where one party's claim to the deposit is clearly wrong. Keep in mind also that some courts strictly enforce time deadlines in contracts, while some don't. So if the seller wants to close on a backup offer after the closing deadline has come and gone, that seller will need to speak with legal counsel before they accept another offer. Question 4. I'm representing a buyer who was made an offer on a home. The seller countered our offer with a clause stating that the buyer waives his right to inspect the property. Is this permissible? The answer here is yes. The seller is certainly free to propose such a clause in a counteroffer, but it would ultimately be up to the buyer to either accept or reject that provision. Well, that wraps up another installment of From the Mailbag. For more information on this topic, be sure to check out its companion Letter of the Law video, which is linked in the description. Please send any questions or suggestions for new topics to the email listed below. Based on input from you, as well as the Michigan Realtors Legal Hotline, our legal team will continue to work on content to help you as a realtor. Again, thank you for watching, and we'll see you next time.